this Wednesday morning, April 9th, and we have official testimony on H86, and we're going to start with Ted. Is it Dyers? Did I pronounce that right, Ted?
It's actually Deers. Can you hear me okay?
Oh, yes, we can hear you, Ted Deers. So identify yourself for the record and please proceed.
Thank you, Mr. Chair. For the record, my name is Ted Deers. I am the Assistant Director for the Water Division at the New Hampshire Department of Environmental Services, and it is a great pleasure to be with you this morning. So I'm going to kick us off and kind of just talk about how we got where we are in New Hampshire very briefly, because I know that you all want to cut to the chase and start asking some questions about the legislation you all have in front of you. So our adventure in the salt world starts basically in the early 2000s. We had a proposal to expand the highway, Interstate 93, between Manchester and the Massachusetts border. That proposal would have taken the highway, and eventually did take the highway, from being two lanes each way to 4 lanes each way. And with that comes the commensurate, increase in paved surfaces, parking lots, all the accoutrement that goes with a highway, all of which needs additional chlorides. At the same time, there was some science in that area, some monitoring that identified that we had some high chloride levels, that is really coming from salt, and exceeded our water quality standards in a number of different places. So as part of that whole effort, we began looking at, okay, where's the salt coming from? And in doing some work on kind of coming up with what's a TMDL, a total maximum daily load, which is essentially a salt diet, we identified that by far the greatest contributor to that salt was not the highway itself, or even the municipal roads which were around it, but well over 50% were related to the private development and basically parking lots and driveways and such. So we launched a program in the late 2007, 2008 timeframe, a voluntary program modeled on Minnesota's program, time-honored tradition for the states to basically steal each other's programs on this stuff, which is great. And we did voluntary training for a number of years, but we heard from our contractors over and over again, they really wanted to use less salt, but they were afraid that if they did, that they, even though, really the roads were going to be safe, the parking lots were safe, they met their contracts with their property owners, they were concerned about an increased liability as a result of actually reducing their salt use. So we had those conversations with our legislature, and it took us a few sessions and managed to get past the legislation, which is similar to what you see in front of you. Since that was in 2013, since that time, that legislation has had a number of different changes. Since that time, it has been essentially non-controversial. We've been back to our legislature, I think 3 or 4 times now, to fix various different pieces of the legislation as we learned from it. And we recently added, and Aubrey can talk a little bit more. She's our salt coordinator, our salt reduction coordinator. She can talk a little bit more about the new program, which we just passed, a municipal program. So municipalities can also get certified. So with that, I kind of just going to turn it over to Aubrey, talk very briefly about how the program actually works, just so that you can sort of understand the sort of mechanisms that we use, the administrivia that accompanies this. And then she'll turn it back to me, and I'll say just a couple of words about the liability, the limited liability relief that's afforded by this legislation. And then I'm going to really just turn it back to you all to ask questions. And we brought Mike Johnson with us. He was an attorney on a case recently that was appealed, went through the entire appeal process related to the Green Snow Pro and the limited liability relief. So we are here at your disposal to have that Q&A period. So with that, why don't I turn it over to Aubrey for just a moment and talk a little bit about how this program works.
Awesome. Thanks, Ted. Hi, everyone. Thanks for having us here today. I'm Aubrey Velker. I'm our Salt Reduction Program Coordinator. So I pretty much manage all the admin side of our Green Snow Pro program. But just a really brief outline of, how someone gets the certification and how do they remain certified. So there's two main steps for an applicator to become Green Snow Pro certified. The first one is they have to complete coursework and pass an exam. We have a number of approved coursework options. We partner with a few different organizations, including the University of New Hampshire, Smart Belt Salt Council up in Canada, the SIMA, which is the Snow and Ice Management Association. They provide all different trainings that we approve. And, so applicators have a number of training options that they can do, kind of what works best for them. There is fees associated with these trainings. These fees vary very much depending on the type of course they are completing, who they are completing it through. All of our training providers, they set the fees for these courses and receive all the money from those fees. So our Department of Environmental Services, we don't receive those training fees. Those are all set by and received by whoever is doing the training for that. In addition to completing the training, an applicator must submit an application as well as an application fee to us at the Department of Environmental Services. Just doing the training does not automatically certify them. It is just the training. We are in contact with all of our training partners who let us know, they report back to us on who's completed the training. So in addition, they need to submit an application to us, an annual certification fee, and that annual certification application fee is what gets submitted to DES. And as is a fee-funded program, that application fee is very important to keep the program up and running. The fee varies depending on the type of certification one is looking for. So first off, there is what we call the individual certificate, and that's generally for the person who's just kind of by themselves. They're not part of a big company, just kind of the one guy on a plow type person. And that is an annual application fee of $150. For our larger companies, how we have it set up is typically one person is the master certificate holder. They're generally overseeing all the certification. It's typically either a supervisor or owner of a company. And that annual application fee for a master certificate is $250. For the rest of the crew in their company, typically then everybody is a subordinate certificate holder. They are still responsible for completing all of the coursework and training, but all of their kind of salt use reporting falls under their master certificate holder. The annual application fee for the subordinates are $25 each. However, we cap that at only charging for the first 4 subordinates, so a max of $100 annually for subordinates for one company. So generally, most companies that have 5 or more applicators are looking at $350 for an annual application fee. And so once they kind of submit everything, have all their documentation to us, I review it. As long as everything's good, check to make sure they got their training, they receive their Green Snow Pro certificate for the year. And this certificate does expire June 30th every year, so they have to renew their certification annually. So this means submitting a renewal application, submitting that annual application fee again, submitting an annual salt use report to us to kind of see how much they're actually putting down, make sure they're keeping some record of that. And in addition, they also have to complete training every 2 years. So they take their first initial training, pass an exam. Every 2 years, they're required to take additional training. Again, lots of different options for doing this. We're continuing to grow that coursework. Another option that especially our larger companies take advantage of for saving some costs on those training fees, especially for our companies that have 30, 40 people needing to complete training, is we have an approved trainer option. This approved trainer option allows somebody in that company, typically it's our master certificate holder, applies, becomes an approved trainer. They apply through us at the department. Once they are approved, we share with them all the training materials. There's a PowerPoint, there's exams, all that fun stuff. And they are allowed to give all the training and coursework to the rest of their crew, so to the rest of their subordinates. So that way they're, not having to pay all those external training fees for all their subordinate certificate holders. The master trainer still has to complete their training through one of our outside partners to make sure they're still getting that education from elsewhere to kind of bring back to their company. So a few different ways to get training, save on that cost, but really most importantly is they have to make sure that they're renewing their certification each year. We have definitely seen times where they've lapsed in certification, which doesn't help if they have a slip and fall claim and they were not certified at that time. And then I think, really we've seen huge growth in this program. Back in 2013, kind of right before that limited liability component came in, there was only 35 certificates issued. This current winter season, we have issued over 700 Green Snow Pro certificates, and that's from 136 different companies. So we're really excited to see all this growth. And then, as Ted mentioned, we recently passed our municipal Green Snow Pro program. That was in May of 2024 that those rules got adopted. So we're excited to see that grow this year. It is set up a little bit differently from the commercial side. With the municipal, there are 3 different certification options. There's a standard, advanced, and expert. Standard certification is kind of similar to our commercial. Everyone needs to complete the same required coursework. They need to have a salt reduction plan. We also have, they need meet certain requirements for storing their materials as well as recording calibration. If a municipality kind of goes above and beyond, they can go for an advanced or expert certification. And this requires them to implement and keep records of different best management practices. They do get to choose from a long list of best management practices to implement. So that way, they can kind of choose what works best for their community, financially, the size of their community, the type of roadways they have on their community. If it's a small town that's primarily dirt roads, something like brine isn't going to be the best investment, but we have lots of other options they can kind of pick and choose. So with that, I think I'll hand it back over to Ted to talk a little bit about how the limited liability has played out for our commercial applicators.
Before you go back
Sure.
to Ted, there's a couple of questions. Ken?
Good morning. How many people do you have oversee this whole operation? It sounds like it's kind of complex.
So it's just me who is really managing this program, and I am a part-time employee. Fortunately, I do have lots of great colleagues that we definitely pull in to help us with some things, especially during our busy season.
Okay, and my next question is, we have a lot of back roads in Vermont. Maybe, I don't know if you do, but we do. What are your other options for those roads that you're putting down for material? I assume sand. What else?
Sand is definitely the most, what's commonly most used. Sometimes, depending on the operator, they do like a sand salt mix.
Yeah.
But yeah, a lot of the training too is also focused on, just plowing the roads first before you even put anything down, not just letting the salt try to melt the ice because that ends up using a lot more salt. So it's focused on a lot of different things, not just the application of salt, but other things you can do as well to help mitigate whatever material you're putting down.
Okay, thank you.
Yeah, I would just add to that the primary focus is on those parking lots and driveways. And, when we've looked at where we have impairments for chlorides around the state, it's generally in those most densely populated areas. And so that's really been the focus of the program. We do have other programs which focus on gravel roads and gravel road maintenance and all those kinds of things, more from a pollution non-point source kind of thing. Like many of the programs you have related to phosphorus and Lake Champlain. Just really quickly, one of Aubrey's jobs that's important, as you noted, she has a lot of things on her plate, is that if there is a slip and fall case that goes forward, we're requested to provide the documentation we have relative to the status of that particular individual or company related to the Green Snow Pro certification. So we provide that information, and it goes to the attorneys involved in the case, and we're able to provide that. What we don't provide and this is one of the things that's required of these companies, is they need to document their practices. They need to keep that documentation. They need to store it. They need to have it for a period of years, basically the statute of limitations period, and they need to have that available in case the need ever arises for them to show what was going on in that particular parking lot at any particular time. We definitely have our share of slip and fall cases. That is for sure. And if you Google, slip and fall attorneys in New Hampshire, you're going to get a lot of pages of Google hits on that. So I would just say it's still a thriving business here. And one of the things that again, I want to just sort of point out the origin of this legislation is really about making sure that people can have the latitude to be able to reduce salt, but still keep people safe. One of the things that the research has shown around the country is that people generally are applying 25 to 50% more salt than is actually needed in order to keep the roads safe. If you walk across a parking lot and after the snow is stopped and after the sun is out and after the parking lot is dry and it still crunches, that means that they used a lot more salt than they needed to. Salt only works when it's in liquid form. So if it's got a lot of salt just sort of hanging around, that is not doing anything. So this is the kind of problem that we're trying to solve. And that's one of the reasons why this legislation occurred, was to identify the fact that you can actually reduce salt. We have best management practices which allow you that show you how to do that. We have, there's industry standards for what needs to happen in order to keep people safe. And there's contractual standards that occur between the parking lot owner and the consultant or the contractor that also dictate what has to happen in those cases. So when it comes to those kinds of slip and fall cases, the state is largely absent from that conversation, save the information that we provide. In general, what we've seen in terms of, kind of our history here is that a lot of cases do get settled. I think that anecdotally, we've heard over the years that there's a lot of cases that get withdrawn, that never see the light of day. And then there's, I think that the Green Snow Pro certifications also does grease some of the skids towards some settlements that otherwise might occur. We've had very few cases that have gone to trial, one that we know of, and that's where Mike Johnson is here to talk about that case as well. So I'm going to stop there. I don't know if Mike, if you want to say just a couple words about the case that you had that kind of went through this whole process, and then we can see if people have questions.
Yeah, before we go to Mike, we
Sure.
do have some questions. Tom?
Yep.
Oh, Barbara, did you have a question also?
I did, but
Okay.
Tom, go first.
I'm sorry, Barbara, then Tom. Yeah, that's good.
So you kind of alluded to the fact, and I just Googled slip and fall ice, New Hampshire. So do you have any sense of if the volume of cases changed after more people were, or for people who are using the Green Snow program?
It's notoriously difficult to track these things. The way that the databases are set up for our courts, it's hard to kind of have those kinds of search words in a common database. So we don't know, what necessarily was a winter time kind of case versus what was, somebody who was just walking across a parking lot in the middle of summer and turned their ankle. There's no way to determine that as far as we've seen. You would have to go, you would really have to dive into, maybe looking at a particular court over a course of a couple of years and and really dive into those kinds of tort cases to figure that out. I would that would be a great project for one of the students at Vermont Law School. So that would, if any of them are ever interested, come talk to me. I'd love to set them up with that project.
I'd like to say that I just went on the New Hampshire Green Snow website, and it's so well done. Like, you make it so easy for people with the forms and downloading, and it's impressive. So, yeah.
Thanks. That's all Aubrey.
That's our web text. We did a lot of changes to that last summer. So thank you. That's definitely our web text though that do that.
Nice job. Kudos. So,
Tom?
This could be for any one of you, I guess. Have you gotten a read from all your contractors that are involved in this on, I guess, what's the best selling point for them? Is it the limited liability issue or the green issue?
It's all of the above. I would say that the limited liability relief is certainly a carrot that brings people in, and I think that that's really been important because it does provide them with some. I think it provides them with a good reason to go get this. Once they're in the door, though, what we find is that there's a lot of reasons why people do this, and one of the big reasons is to save money. We have heard from a number of companies that they've reduced their salt use by well over 50%. That's money. That's money back in their pockets. Companies that move to brine in a big way save time. They save overtime. They have equipment that they're investing in. There's a lot of these best management practices that are bent to get a better product that is a safer road out the door. Once they learn about how to do some of these things in an efficient way, the entire industry is moving this direction, albeit very slowly, to try to get those kinds of new products. There's products that weren't available 20 years ago out in the world that are becoming more commonplace. So, I think that. But there's a lot of people that have tried to use this for market differentiation. People that have marketed themselves as greener than others. A lot of people use it as a training opportunity. But again, for most people, for most businesses, this is a business decision and it has an economics associated with it.
Thank you. It's exactly what I was looking for.
So why don't I turn over to Mike
Yeah.
for just a second? And I apologize.
No,
I'm
we
gonna
have
to leave,
another question.
Okay, I'm gonna have to leave in about 10 minutes, and I'll turn you over to the other folks here. I have to run to another meeting, but
Okay.
I'll go ahead and answer. We can answer that question, and then we'll move along.
Thank you so much. And it may be a question for Aubrey, I'm not sure, but I'm wondering if you can talk a little bit more about the data keeping requirements, and is that part? I'm assuming that's part of the training that folks receive. And if the data that's like how specific that data is, and in terms of like I guess how location specific and things like that. And maybe this is something that Mr. Johnson will bring into his what he's sharing as well, because I'm just trying to imagine a lawsuit moving forward and what kind of information would be available, how specific and helpful that information would be.
Yeah, I can definitely talk on that. So there is, I talked about, the documents that they have to submit to us to renew their certification each year. But in addition to that, there's additional documents that they need to keep for that limited liability component that are not submitted to us at the department, but they still need to maintain and be able to have on hand. Those include, I'm actually going to read directly from our RSA, that these records need to include the type and rate of the application. So the types of de-icing materials that they're using. So whether they're using salt, they're using magnesium chloride, the application rates that they have applied them, the dates of treatment. So every time, every day that they go out and treat pavement, they need to keep weather of that. As well as the weather conditions for each event requiring de-icing. And then for the kind of annual salt use report that they submit to the department every year to renew their application, that also includes, how much pavement they have treated, as well as the towns or cities that they've treated as well.
Thank you.
I just had a couple questions before we we go to Mike. So, any idea what the savings on somebody's liability insurance is? Like, implementing this
Yeah.
program?
My what we hear is that nobody ever saves anything on liability insurance. Um, the question is, can you get insurance, and can you keep insurance, and how much does it go up every year? Those are the bigger questions, and we certainly have had a lot of interest from an insurance industry, and certain again, when you think about market differentiation, we have some insurance agents who have been very aggressive in trying to get their clients into this program, and some insurers who have been more aggressive than others in trying to get their get people into this program. The insurance industry is a very, very complicated one, as you might imagine. And so how prices are done, how all of that works, there's a lot of noise around this, and this would be one of the programs that probably sits in that noise. But like I said, I think it has, what we hear is that it certainly helps these folks who are renewing their insurance policies from year to year to be able to show their insurer that they're doing everything they can to protect that investment.
Sure. And I think this question is for Aubrey. I'm not sure. I think you said you have around 700 people that are certified in the state. And I'm wondering if you know how many applicators there are in the state total.
That is a
If
question
there's a
we would love
guesstimate.
to know. We've, definitely tried to figure out ways that we could find out, how many winter management applicators are in the state. Unfortunately, it's another one of those things that's very difficult to figure out.
Sure.
Because then we have some of these bigger companies that have 30, 40, 50 people, but there's also a number of kind of smaller companies that's just one or two guys kind of doing it as a side gig. So we really don't know. And there seems to be a lot of people kind of going in and out of the industry. I definitely get emails from people who have been certified and said, hey, we're not doing snow and ice anymore. Sometimes because of insurance rates, sometimes it's because they decided to move to Florida for the winter. So very difficult number to actually know. We wish we did,
Sure.
so we could reach out to all of them.
Yeah. And I'm wondering what your annual budget is.
Annual budget for our program, which just really covers staff and a few other pieces, is right about $100,000. I would submit to you that is too low, and we definitely I think that this program probably needs two people to be really fully operational, and I think as much, there's times of year where we have to augment absolutely what Aubrey is able to do, and we would do a lot more if we had another person. The other piece that I would just point out is that there are some costs associated with databases, websites, all of that kind of stuff. We have to keep very good records because this has legal implications. We have to keep very good records of everything that we do. If I really had my druthers, Ohio has a great program where they're providing low interest loans to companies who are trying to get into brine and trying to do other best management practices that are going to reduce their salt usage. That would be the holy grail for me, to be able to have that kind of a either low interest loan or grant program that I would be able to provide that kind of assistance. And I think that I think that would really help us to reduce salt rates around the state. I keep, saying the word tax in New Hampshire is kind of like a 4-letter word. And so that's not something that we're looking at this moment. But, I think someday some sort of a surcharge, we'll call it a surcharge instead, that a surcharge of some sort on bulk salt or something like that, could help to fund something like that. But that's I think a ways down the road.
Right. I'm guessing with $100,000 budget, you don't have an outreach or education program to pull people in.
We do. I mean,
Right.
Aubrey is one. She is.
Okay.
She isn't. But we have other people who jump in with that. I mean, she's done amazing things. She sent Valentine's out. Be mine. use some
Each other
brine,
from-
those sorts of things. She sent Halloween cards out. We've
Okay.
done events. We do a salt symposium partnering with the Snow and Ice Management Association. They do a lot of outreach for us. We've generated a lot of interesting partnerships with UNH, their T-squared program. That's our transportation. They work with all our road agents around the state. So we've by hook or by crook, we have been able to, and I think this is probably how Vermont works as well, is that it's really through those partnerships and community community of practice that we're able to have the kind of reach, the reach beyond our grasp that I think is really important for a program like this.
Right, and if we do implement this, I hope we can get an Aubrey here in Vermont.
Just don't steal
Because-
mine.
Do a-
Well, and the reason I'm saying is we're not as afraid to tax over here for number one. And this bill actually has $400,000 attached to it. So if we implemented your program in Vermont, and we're a little smaller than New Hampshire is, it'd be nice if we could do for $100,000.
I look forward to you all doing great things. What we're learning is that each state is adding a little something to the knowledge of how we're doing this. Each state has a little something to add. And as soon as Vermont goes forward with this, if that happens, you will innovate, you will identify ways that work, and you'll be teaching the rest of us. I assure you that this will be you will be an important player in the snow belt with regard to these issues.
Sure. Any other questions?
With that, I'm going to leave you in the capable hands of Mike and Aubrey, and I truly appreciate it. And feel free to call on us at any moment. We're happy to answer questions, happy to do whatever you need to get resolve these in your own mind. Great.
Thank you for your time.
Thank you.
And Mike, if you could unmute, introduce yourself, and go ahead.
Sure. Thank you very much. Is my microphone all right? I was told that it was making some noise.
It sounds good right now.
Perfect. Okay, great. Thank you. So thank you for having me. My name is Mike Johnson. I'm an attorney. I practice in New Hampshire, Massachusetts, and Maine. I've been licensed since 1998. I'm at the firm Boyle Shaughnessy. We actually have lawyers in an office in Woodstock. So one of my partners, Tom Fay, runs that office. So I'm not licensed in Vermont, but I can tell you, I think I was asked to be here because I have litigated these cases in New Hampshire both before and after this law went into effect. And I'm told that the case I tried in Rockingham was the first one to go to jury verdict, to have a jury decide the case on the issue of the Snow Pro certification. So I want to just correct what Ted said, that we were successful on that case. The plaintiff appealed it, but they dismissed their appeal. It never went through the whole appeal process. It went through the whole trial process, is what I think Ted was trying to get to. So I have a few observations, and some, it's good going third because I get to look at some of the questions that you guys had, and they're really pointed questions. But a few things that I just wanted to address first off is that the number of cases, I'm with Ted in the sense that we can't figure that out. However, I can tell you that it doesn't seem like the number of cases have gone down. In other words, people's rights aren't being quashed because of this bill in New Hampshire, or this law in New Hampshire. People are still bringing these lawsuits. They bring them. We figure out if there's a Snow Pro certification. We do all sorts of things to try to limit the liability, but it hasn't stopped people. I think one concern is that I'm a big proponent for people, and I defend cases, but I'm a big proponent for people to bring lawsuits and to assert their rights if they're injured. This law doesn't get rid of that. Unlike the immunity that's afforded to to ski operators and equine operators in the state of New Hampshire, we don't see any of those claims because that's an absolute bar to bring suit. This law is not. It's a limited liability. We have to prove certain things as a defendant. And also, it doesn't only protect large property owners or large enterprises. And it does not impose an additional burden to the plaintiff. That's something that I think been kind of distorted on, when New Hampshire first imposed this, a lot of people thought it was going to limit the plaintiffs from bringing these lawsuits and put extra burdens on them. In my experience, when this law first came into effect, we all were aware of it when it was coming down the pipe. And a lot of plaintiffs' attorneys thought it was going to end civil litigation, slip and fall cases. I said, I don't think that has happened. People are still bringing them. The dockets are still filled with these cases. We still see them on behalf of property owners. We represent property owners. We also represent the snow removal companies themselves. The large corporation, I heard some testimony regarding, it only protects large corporations like Walmart or McDonald's. I'm familiar with Vermont, even though I don't practice there, and I know there's a lot of small businesses, much like New Hampshire. A lot of these I would say all of the companies that do the snow removal are very, very small companies, and it protects the small property owners. Particularly the case that I had that went to trial was a small apartment complex that was owned, or a condo association. And I represented the snow removal company in that case, and it was a small company, small business. The idea that it adds an extra burden to the plaintiff, I think, has been misconstrued. What it does in these lawsuits, if I defended a case, and I have one going right now where I represent a property owner that's being sued for slip and fall, first question I asked my property owner client was, who's your snow removal company? Who does the work? Are they Snow Pro certified? Are they a certified snow applicator? If they don't know the answer to that, I then send the record request to Aubrey's office to get reports whether or not that company is. And then I send a subpoena to the company to get their data and their records. But the burden to prove this is on the defendant. So in the case that I tried, in most, I don't know how, if anyone, I'm assuming some people in the room that I'm talking to are attorneys, but typically the plaintiffs have the burden of proof. In most cases, they have to prove negligence, duty, breach, causation, damages. They have to prove those by preponderance of the evidence. When I assert this as a defendant, I'm asserting it as an affirmative defense. Now, the court has interpreted that to mean that I bear the burden of proof on that issue. And in the case that we tried, the judge issued jury instructions, and the jury instructions laid out those 5 elements that have to be proven. It's kind of complicated. It was kind of confusing, but we were able to wade through it. The defendant has to prove that they or their snow removal company is a commercial applicator, that they had a contract with the snow removal company or the property owner, that the claimed injuries that arise from insufficiencies or hazards on the premises owned or maintained by them, and they were caused by snow or ice, that the failure or delay in removing or mitigating such hazards was not the result of gross negligence or reckless disregard of the hazard. 4, that the failure or delay to remove the mitigating such hazards was a result of implementing the best management practices for winter road, parking lot, and sidewalk maintenance. And 5, that they kept written records describing the winter road, parking lot, and property maintenance practices. And they include what de-icing materials we use, the quantity, and the dates of treatment. So puts an extra burden not on the plaintiff, but on the defendant to prove these things. And, so we've had these cases go through the stages of litigation. I first moved to dismiss based on the fact that it's a presumption that we followed best management practices. Every case I've had where I've moved to dismiss, if I think I have enough to move, we get denied. Then we move for what's called a summary judgment, which is, another dismissal at a later stage. And most of the cases have been denied. This case went to trial, and we had to prove those elements, those 5 elements. Basically, we had to prove that the person slipped on snow and ice, and the snow and ice was there because we implemented these best management practices. So it was a little confusing and hard to maneuver during trial, but we were able to do it. And I think it adds I got to tell you, my client in that case was a big proponent of it. He was a very green-minded gentleman, and he had his staff trained on the best practices of how to use less salt. He enjoyed the liability protection that it offered. And I got to tell you, a lot of my insurance company clients are very, very interested in it. And I agree with Ted. No one ever really saves on the insurance premiums. But I do know every client that I've had cases for that do snow removal and own property, and they have an active case, they're always telling me their premiums have gone up, or they're being denied coverage from other people. So I think the insurance company has taken an interest in this for that purpose, for trying to limit the liability. But it's certainly a manageable proposition. Like I said, I probably have 6 or 7 cases that are ongoing right now that involve slip and fall in New Hampshire on snow and ice, where we're trying to track down this information from Aubrey. And I just found out that Aubrey's a part-time employee and the only one there, and I never have a difficult time getting in touch with her or anyone with Ted's office. So that's amazing that it's only one person.
Any questions? Barbara?
So this is helpful because I think you alluded to, we heard from an association of trial lawyers yesterday, or I should say personal injury, who were concerned about access to justice. But it sounds like that's not been a huge issue. The other question, which I think probably is for the person, and I'm forgetting his first name, who got off, is it sure sounds like it would be an amazing collaboration if Vermont passes this law to work with New Hampshire, because maybe we could have a really cost-effective program by combining resources, since it's figured out already. So anyway.
I would like that. I think we can definitely find some sort of partnership to do there.
So my other question is, I was just thinking about homeowners or renters who, this has been informative to me because I'm sure oversalt my driveway and front walk because I don't want the letter carrier or the newspaper delivery people to fall. Has New Hampshire tried doing any kind of incentive with homeowners or renters or individuals?
So we've tried to do a lot. Well, I should say we're now trying to focus some of that outreach onto kind of just general homeowners and community members. Because as Ted mentioned, we see a lot of these giant parking lots that are completely over salted, mainly because a lot of people just don't understand how salt works. And a lot of times that happens because community members are complaining, hey, there's not enough salt, even though it's completely safe. But as far as really incentives for homeowners, we don't have, a certification program for them unless they were to hire a commercial applicator that is plowing their driveway for them and is Green Snow Pro certified. They then get that limited liability protection as well. But definitely one of our next big steps is trying to focus on, the general homeowner and what they can do. With previously the kind of focus has been these larger parking lots because that's where we're seeing the majority of oversalt application happening.
Well, I think it's also a public education piece because when I ran an organization that had a childcare and many pregnant people walking in or people carrying babies, people would be like, you've got to put more salt down. And we would, I'm sure, again, overly salt because if somebody complained, we felt obliged to do something. So again, I'm just wondering how much sort of public misconception plays a role in getting people agitated and wanting actions that generate,
It definitely plays a major role, that public perception, and changing that perception is a very, very slow change. We are starting to see a little bit more of it now. Salt's becoming, a bigger topic of conversation. And fortunately, again, it's kind of where our different partnerships come in, whether it's the University of New Hampshire. We have a lot of different nonprofit kind of lake association organizations that are starting to bring up the conversation more as well, especially to their community members. So increasing that will definitely, hopefully help us continue to change that perception, because that's definitely one of the main reasons we're seeing this over application of winter salt.
Thank you.
No more questions? Michael, thank you very much. Appreciate it.
All right.
And
Thank you.
next, we will hear from Samantha.
It'll be me.
That'll be you. Okay. You don't look like a Samantha, but.
Anyway,
I didn't realize we were gonna get off.
yeah.
Connecting here to show you a presentation, but before I start, for the record, Josh Hanford, I am the Director of Intergovernmental Relations at the Vermont League of Cities and Towns. I've been in this committee, so thanks for having us. Present to share. All right, can I share it? Okay, here we go. So what is the Vermont League of Cities and Towns? We're a member-driven organization. Every municipality in the state chooses to be members. We're nonprofit, nonpartisan, been around since 1967. Our goal is to serve and strengthen local government. In addition to advocacy work here, which is why the LCT was founded, we do education workshops for local officials. We do comprehensive insurance coverage for almost all municipalities in the state. We have an insurance risk pool that we operate and offer to municipalities. They don't have to take it, but I think only 2 municipalities in the state don't use the coverage that VLCT provides. We provide confidential legal guidance from experienced municipal attorneys at free or reduced cost to answer quick legal questions, because that gets expensive. We do a municipal data project. We collect a lot of data and research to help inform municipal officials about everything from salary ranges to best practices. And then we participate in a lot of working groups, legislative task forces, et cetera, to represent the municipal interests all across the board. And more recently, we've been working to provide more technical assistance, such as like grant management, grant writing, really growing out of all the funds that came from the pandemic, the ARPA funds, the Infrastructure Act. There's a tremendous amount of resources made available, but they all come out as competitive grants. And many of our under-resourced smaller communities just don't have the capacity to do that, and they need help. Currently, we're doing some of this work with a cooperative agreement from USDA Rural Development to help folks access. And our team of folks has assisted every single municipality in the state of Vermont obligate and spend their ARPA money and do the federal reporting requirements that are going on now. And even though the ARPA money is ending, still have several years of requirements. Just quickly, VLCT goes through a policy setting process every 2 years to line up with the legislative biennium. We have 5 policy committees, everything from transportation and housing across the board, public safety. We meet. These are all local officials and employees that volunteer their time. And we have, probably a 20-page policy document. Then we take that, and each year we work with the team to develop the priorities for the legislative session. This year's theme, pulling through all of that policy work, was really to support municipalities in meeting the obligations and functions of today's local government and help them take action to solve the problems of the 21st century. The support side is give us the tools, give us the authority to serve your local government, your residents, your constituents the best we can, and then take action with us to do some of these bigger things that we can't do on our own, like creating housing, public safety, et cetera. Now to talk specifically about this bill, generally municipalities are aligned with this effort to reduce the environmental impacts and expenses of spreading salt. Sort of some key areas that anything that you move forward must be voluntary. Municipal resources really vary from community to community, as well as the road networks. If you're going to do this, it must have the support and implementation and funding for compliance and oversight. New Hampshire's differentiates between their municipal and their commercial applicator programs, which you heard a lot from. The municipal requirements that they have are quite modified from their commercial applicator program. But really, one of the things that I want to get into is about the liability protections that this program talks about, and really how specific this call out is. It's just, you heard Mr. O'Grady talk about it, ice and snow. What about the dip in the parking lot? What about the cracked and missing piece of the sidewalk that the municipality doesn't have the resources to fix because the voters haven't approved a tax increase to pay for it? This is a very small liability protection that we feel actually goes in the wrong direction. That there's a bill up on your wall, H138, that is more broadly about monetary caps on liability for municipalities that we would ask you to consider. The state of Vermont passed a monetary liability cap for itself in 2011, which caps individual lawsuits at $500,000 and combined at $2 million. Interestingly enough, the state you heard from, New Hampshire, has a monetary liability cap on municipalities of $325,000 per incident and $1 million cap. And our neighbors to the south, Massachusetts, have a monetary liability cap on municipalities of $100,000. You know who doesn't have a monetary liability cap is New York State. And I think if folks drive there a lot, they see a lot of salt on the road and a lot of salt on municipal sidewalks. The carrot that is being offered here is the wrong approach. What we should be doing is protecting taxpayers, your constituents, your residents, because they're the ones that pay the bills from slips and falls. They want to reduce their costs. They want to keep their citizens safe. But when we have a situation where we don't have the same protections as even the state government, and we have lawsuits, there's a memo that was sent to you talking about 2 existing lawsuits in communities in Vermont that are recently settled, as high as $9 million. Who pays for that? The residents, the taxpayers of a municipality, when the state has protections. So think of a slip and fall here on the State House steps. There's a monetary protection. Slip and fall on the Montpelier's office steps, there's no monetary protection. So I think we're offering a carrot to look and say, hey, thank you for offering the carrot, when the reality is we should be protecting our government, our local government that's made up by the people, and the consequences of not protecting them is paid for by the people should be the underlying premise. Then communities can start talking about lowering salt or other sort of safety measures that might help the environment, reduce costs. They're all for that. But there's a baseline of fairness that isn't applied here in Vermont as there is in these other states, and even in compliance with state properties and what you offer there as a monetary protection. It doesn't limit the ability for people to sue as a recourse. It just puts a cap that doesn't have a potential of a municipality to go bankrupt. There's a very prominent case recently of a small town in Georgia that had a $38 million settlement. The town literally went bankrupt. The state had to step in and change its laws because of a lawsuit against the municipality. One of the examples that is up on your website describes a road issue right here along River Road, close to Montpelier, of a lawsuit, a settlement, $325,000, I believe it was, for improperly maintained road. So these are real issues. Folks in Vermont go after the municipal employee, and the municipality has the duty to defend them. We do not have sovereign immunity for the municipal employees. And so we think that if you added the protections in H-138 to this bill, you would have a much better chance of having municipalities participate in the training, actually implement and work towards reducing salt. It helps their budgets, and they do also have a desire and obligation to assist with water quality. They spend money every year rock lining ditches and replacing culverts and responding to floods to try to reduce water quality impacts.
Okay.
Can we just back up? You said $345,000 for some road down here. What was that? What's that all about?
There was the memo sort of describes it to the extent we can, but there was a settlement of a driver on the road that won a lawsuit settlement against the community for $325,000 of a improperly maintained road.
So can I ask you a question? Why would anybody, the cost of salt, the cost of applying it as many times if you've got to do it, why would anybody with any common sense, I'm going to use that word lightly around here, but why would we be over salting anything unless there was a risk, which I assume is nothing more than lawsuits? What am I missing?
I think you're right. I don't think a community desires to oversalt, to overspend its resources. I think they want to keep people safe and reduce slips and falls and lawsuits. I think the example of a business or a nonprofit that maybe is serving people that are elderly or pregnant, that they're worried about their safety. So they salt to make sure people are safe.
But we all know you can go and you can slip and slide and fall on too much salt being on the road. It's slippery. I mean, if it doesn't melt, you know what I'm saying?
This is I wanted to. So it was the town of Moortown, and it was a $300,000 settlement. The claim was there was negligence on the town for maintaining the road with a grader. The point of this that I want to stress as well is the provisions in H-138 on your wall over there don't remove criminal penalties. If a snowplow operator was acting criminally, they were drunk on the job, but that's not the protection that anyone is seeking. It's the same protection that the state has for its properties, its state parks, its state forests, its state buildings that municipalities would really benefit from when we see cases like this in Brandon of a $9.1 million settlement. That impact Brandon's residents' cost of living.
Does select board know about it?
Oh, of course. Yeah.
It's just checking. I got another thing. So I noticed in New Hampshire a couple of years ago, that, that they started cutting the trees, expanding the trees, so Mother Nature could get in there, the sun could get in there, the elements could get in there, and I assumed immediately. I noticed we're a little slow to the table, but we're starting to do that more. I assume this is all part of the process that we're trying to get to, even though that's more probably state level, although I know it's been done in local towns. I might have been involved in one, and I got serious pushback. You know, the 3 rods or the 25 feet of it, you know, the right of way. And but it was better road practices. It was better maintenance of it, runoff, storm runoff. Again, going back to the maintenance of proper drainage and all that stuff. I mean, we've changed practices a lot over the last 20 years in doing this. What more do you see that we can do to help the situation?
Well,
I mean, I obviously the oversalting I get, which is just mind-boggling to me that anybody is going to go out and do that. It's like,
yeah, I mean, I think that the goals of this program and to have A&R work with AOT and have the local roads program provide training for municipalities and how to reduce their salt properly, still maintain safety. There's nothing wrong with that. I think that's a training that should be offered and should be available. We're just saying from a municipal perspective that very specific liability protections, the juice isn't worth the squeeze. Your example of the road, the line sight, any good attorney, if there was an accident and someone was looking to make a claim and the municipality had this liability protection for the ice and snow removal because they were enrolled in this training program, maybe the line of sight wasn't proper, you know, because the trees weren't cut far enough back. Maybe the huge missing piece of pavement that they haven't been able to keep up with the payment costs as the transportation budget goes down. There's a lot of other ways you can find accidents that aren't just because of the salt and ice that's still on the road because of a reduction in salt usage. And that if we're, I don't think government provides the services and the safety solely by the threat of lawsuit. It's a different sort of calculus. You do it because your citizens demand it. Your residents want safe. They want to balance that out with the cost of living and a whole bunch of other things. And you make decisions as a government all the time. So I don't think the carrot is the right way to approach protecting government from lawsuits, frivolous or valid. I think protecting the citizens and the taxpayers from expenses so they can do more good as some of these cases have been brought forward. The other example we had, I just want to point to, if I can get to that other memo we have here, there's a quote from a Vermont Supreme Court judge that an excerpt from Justice Dooley. This was a case about these liability protections. And this quote is pretty representative of what I'm trying to say, that I'm just going to paraphrase here there, but government programs without the protection will be scaled back. You won't have your rec facilities, your skate parks, your swimming pools. And in today's world with climate change, this really gets real for us with dams. Municipalities own dams. They don't have the protection of the state if a state dam fails. And some people say, well, why would you want to take that liability cap away? Don't you want to protect the people that are downstream? The people downstream are the people in the town that pay for the insurance. They're the same people. And so these threats to government because of liability concerns, if mass failures are really consequential. And we need to have these monetary caps to protect the good that government should be doing rather than protecting its liability concerns and removing services is our basic principle and ask here. This program, this goal is great. We have no problem with it. But look at the states that are doing it. They have liability monetary cap protections already as a baseline that you can build on to do this type of work. It'd be much, yeah.
So before I have Ian, but before we go, I understand and respect that you're trying to get 138 into this bill, but H 138 is a much bigger issue than just this incentive for following the salt applicator being this liability protection. So, and I do hope this biennium to take that up. I'm not promising that it will move at all, but it's definitely a bill that I sponsored, and I do want to have that discussion. But it's a much bigger discussion, and I guess I am concerned that overall, if we did something like 138 and had this overall liability cap, that's disassociated from the incentive that we're trying to have for the salt application. I mean, that there won't be the same kind of incentive, I think, to follow those rules if there's that cap, presumably. But I guess the question I have is, if you're not getting 138, you don't want the liability protection that this bill does offer? I just want to understand that.
Oh, I'm not saying that. I'm just saying that this protection is so narrowly focused.
It is narrow.
I think will
I
have
understand that.
barely any impact.
Right. I do understand that it's much narrower than 138, but go to Tom and then Ian.
Just for clarity to anyone, I mean, are municipalities built into this?
They're built into it in
I
a way
see.
that's changed several times
Well, I
from
see
the Senate
commercial
bill
salt
and the
application.
Senate. Yeah, they're built under the local roads training program. So I don't really know if we have an ability to opt out or be voluntary if they're changing the program to just say, we're going to offer this training to you now about how to reduce your salt application. And there's a requirement that your applicators have had the training within 365 days. Well, often you're hiring, a road crew to do this work in October. When was the training that the local roads program had the one time during the year? What if someone changes in the middle of the winter and you have to hire a new person that hasn't? Those are unanswered questions. I think it's a valid point that any liability protection we'd appreciate. I just think there's a whole bunch of underlying decisions that municipalities make about safety of roads, including salt application, how much to plow, when to plow, that go way beyond this and speak to the general monetary caps that we don't have, that the state has.
Seems to me we would start with probably our largest salt spreaders in the state would be the municipality.
I believe that the data from ANR or Champlain Basin program did indicate that municipal roads spread more salt than state roads. I don't remember if the commercial applicators were about equal or not, but I think that's fair.
Well, there's just a lot of municipal roads up. Okay, thank you.
Ian and then Tom Burdick.
Actually, my questions relate to H 138, which is not what we're debating today. So I'm going to
Along the lines of training employees, we have a three-man road crew in West Rutland. And two of them were hired after the first snowstorms this year. So there's no way they would have the training.
And there's also contract employees.
Yeah.
Many towns use, if they're not enrolled in the commercial side, they weren't trained, are they protected? It really is unclear how a municipality would benefit from this. Again, appreciate any move towards some parity with the state for protections from these lawsuits that unfortunately happen.
So do you have any specific concerns or that you could point to in the draft 3.2 of H 86 and that we could, with respect to the liability? And I understand your broader point, but
I think this, when I switch back to this slide, I think again, I'm talking about the municipality have to prove that the event was caused solely by snow and ice. And the application was according to best practices. The employee and the contractor did not commit gross negligence or disregard. They have to meet the record keeping requirements and attend the training. That could be something that's challenging to provide and keep up with. I think the sort of bar for us on this is if you're going to implement this, it must be voluntary. There must be resources from the state to help ensure this happens. And recognize that commercial application and businesses that are protecting their interests and is different than local government that is the people that we're protecting and paying for the service and paying for the insurance. It's a different calculation that needs to be considered.
Any other questions for John? No, and I think we'll probably be having you back in at some point for the broader discussion, certainly. So
Appreciate that. And thank you for your time today.
So were we still going to hear from Samantha, or is it just?
No, Samantha's homesick today, but
Her testimony.
she sent some just follow-ups you guys had what I was talking about.
Yeah. So before, we're going to take a break before we move on to S45, but I just wanted to get a sense of where people are with 86. So we don't have possession of it, but I think the Environment Committee wants to hear from us on where the input. We can take possession if we want to dig in and change things significantly. But I'm just wondering where are people with us? Can you? Yeah.
I'm just a real high view. I'm concerned about the liability issues and the $400,000 price tag compared to New Hampshire's $100,000 price tag.
Right.
That's.
Yeah, okay. Other folks? Yeah, Rachel?
I guess I would say if the ask of us is to dig into the liability questions for, rather than much more so, or rather than the environmental issues, I don't feel that I know enough yet to form a confident opinion.
Well, let me ask this question, I guess, for folks is I found somewhat compelling the point that we should unless I missed something this morning when I was not in here, that we should see what the standards are that are to replace a reasonable person standard, essentially, before we decide about the liability.
Yeah.
And further for that is that my understanding is the Senate appropriations, they're not putting money in to establish those standards. Who knows where this is going to end, but the issue of if they're not sufficiently funded to get robust standard, that also concerns me. So my suggestion, if people agree, is that, to talk to the Environment Committee and say, we're really concerned about going forward with the liability until the standards are there. Why can't it be a two-step process with a check from us in between of it? Huh?
I've been thinking about this, in obviously it's about environment and it's about safety. And I know in most lines of work, safety, that one of the best protections you can have against successful lawsuits is training and information. And that would reduce, probably payouts in and amongst itself with this. If people were operating under standards that's accepted. And the liability, the insurance part, we learned all about that in the dram shop law, that, capping things is the difference to get different, grading. I think it's a two-piece thing. I'm not so sure about the liability end of it, but we definitely need to environmentally look at this, I'm thinking.
Right. Yeah.
Yeah, and one thing I forgot about, I was thinking about it last night, is why do we need to go this extensive? I was thinking just a simple education program to whether it's bigger companies, applicators, somehow to get the word out there. Natural Resources, I'm sure, does other kinds of education, and I'm sure the state does education. I know the state does education, things like with 802 quits. I mean, that's a lot of education there, which would be a lot cheaper and potentially have the same effect.
So, I mean, I can share that as well, but my understanding is, I think that the Environment Committee believes we need to go further just because we're facing the TMDL concern that we may be forced to do something if we don't try to do something more, but I can certainly, we can share that with them, but Barbara and then Tom. Oh, sorry.
So, I mean, the other piece that Jared brought up is like destruction of bridges and roads, which does have a cost to taxpayers in our state as well, in addition to the environmental and health concerns and being at the limits of the I forget the acronym you just used, but the TMSL or
TMDL, yeah.
TMDL. So I'm wondering, I mean, I'm sure JFO wouldn't be excited to do a cost benefit analysis, but there are savings in some places, and it would be interesting for appropriations to look at the New Hampshire model and maybe Ways and Means, because they charge a fee, right? There's a fee to get your permit. And I don't know how much of that offsets the 100, if it's all 100,000.
No, they sent that one into a different.
Okay, yeah.
Didn't go into.
So I think, I mean, these are good points.
But they're not, I know they're not our.
Yeah, I think our issue is really, are we comfortable with going with a limited liability at this stage where, given where the standards are or are not? I think that's the fundamental question for us to answer, I believe. Tom and then Ken.
Well, I was just thinking much like what I think if we provide certifications and classes, there's going to be some sort of fee associated, and that could be what pays for the project itself.
I contract with New Hampshire for 100,000.
Well, right, whatever.
There we go.
Seriously.
We gotta have Aubrey do it.
Yeah, exactly.
She's part-time.
Yeah, well, there we go. Ken and then Tom.
So all I'm gonna say is fees, taxes. That's where I'm gonna start there. Because that just sets me off. And then the other thing is, we just barely got done hearing about this bill we're talking about, which is fine. I'll go along with that. But there's too much to take in, like Josh's thing with BLCT and all that stuff. That's good, but we're still talking. The thing that I'm trying to understand is why we're putting down so much salt. We had a hard time getting salt. We're under a strict limit of salt, yet, and sand. We have a big problem with finding sand around this state. And it's like, before I say much more, I just need to filter this in my pea little brain.
All right, fair enough. Tom?
Yeah, I mean, it just going through my mind being an insurance issue, if it's going to commerce and for the insurance experts.
Yeah, I can suggest that as well.
Yeah.
You're right. You don't want to be insurance.
Yeah, and I think I would just echo my agreement with waiting until we have the like actually what the standards are. Just given the good work that we're doing on S45, where we're also talking about a presumption, and we're spending a lot of time looking at what are the standards.
We're sending it to agriculture to make sure that they getting the standards right.
Yeah, and so just sort of like, I know that there are different issues, but we're kind of
So you're saying be consistent?
Yeah, I think that would be that might be something worth sort of striving for.
All right, well, good. So I don't think we'll have to go to Commerce if we're taking the liability thing out until they have standard. Right, so. All right, so we're going to take a 5-minute break. We need a stretch break. Sorry, Mike, but I'm going at it for